Welcome to Political Science 201. This is Laura Fleming, and this is our 14th and final lecture. I'd like you to imagine just for a moment that you own a small business and that you need to hire an entry-level person for your small business. Okay, maybe you have an office, maybe you have a little retail store, and the question is, what qualities should you consider and what qualities should you ignore? Kind of an interesting question. Most people will say that they're looking for experience. You know, experience is a good thing to consider. Reliability is a good thing to consider. Education, you know, this is why you guys are going to college, is because you hope that somebody who's in a position to hire you will look at your education. So that's pretty straightforward. What qualities do you ignore? Well, ideally you would ignore certain qualities like race. You know, we all know that it's immoral to hire someone on the basis of their race. But let's go a little deeper. Okay, so I think most people would say, you know, you don't want to discriminate against people based on their gender either. Okay, so you should be open to hiring a man or a woman. But what if you're part of the local fire department and you're hiring a firefighter? And let's say that you have a test for physical abilities. And let's say that despite your best efforts, you're recruiting both men and women, but despite your best efforts, men pass this test at a higher rate than women do. And you know, you're a progressive guy, you'd like to see more women firefighters, but you keep bumping up against the fact that women are not passing this test at the same rate as men. And the question is, should you change the test? Most students would say, you know, I think you should keep the test the same because this is a safety issue. And we, you know, if there's a burning building and you need to be rescued, you don't really care about whether your rescuer is a man or a woman as long as they're able to do the job. And we see the impact of this when you look at studies of women in the military, for example. So women Marines, these are very tough women, and they have passed rigorous physical screening. And yet women in the Marines, women in the military in general, they suffer higher rates of injury. And this is just part of the biological reality that most men are going to be taller, stronger, have more muscle mass than most women. Now, obviously, there are exceptions. There are some women who can take out some men, right? But on average, the average man is going to be physically stronger than the average woman. So we're bumping up against some biological difficulties when we're trying to ignore gender in hiring. What about religion? You know, well, we don't like the idea of discriminating against people based on religion either. And that would apply to most jobs, but what if you were First Baptist trying to hire a youth pastor? Could you consider religion in that situation? And we would say, well, yes, you know, there are some situations where religion is relevant. Okay, so it's a question of where you draw the line. What about appearance? Okay, so in general, you know, people should look professional when they go on a job interview. They should be neatly dressed and well groomed and professional looking, so that's something you can take into account. What if a job applicant is just ugly? Okay, should you take into account ugliness? Research shows that attractive people do get hired and progress in their careers faster than ugly people. So whether the hiring manager realizes it or not, sometimes they do take attractiveness into account. And you might think that, attractiveness shouldn't matter for most positions, but what if you have a position as, a spokesperson or a model, and this person is going to be the face of your company to the public? Do you want somebody with an ugly face representing your company, right? I had a case many years ago where a guy sued a TV station over a meteorology job. Okay, so there were several applicants that applied for the job of weather forecaster, and this guy was very smart. He had degrees in meteorology, and yet he was passed over in favor of an attractive young woman. And the TV station justified its decision by saying, it's for the viewers. The viewers would much rather watch an attractive young weather woman than, this old guy, even though he has his degrees in meteorology. So you see that, there's a lot of gray area when you're making hiring decisions. And even though we like to think that we don't discriminate based on certain characteristics, where do you draw the line? In fact, all of this can be called discrimination. Some of it may be immoral discrimination, like discrimination on the basis of race, and other discrimination, like discrimination between people with different levels of experience, different levels of education, might be perfectly legitimate and lawful discrimination. What about disability? Should you be able to consider disability when you're hiring someone? I have a son who's disabled. He's had a very hard time finding a job because employers are running a business and they want to look for people who they think will do the best job. And people who are disabled, sometimes they can't do the job at all. Other times they may need accommodations that are expensive and time consuming and costly, so where do you draw the line? Where is it justified to screen out someone who's disabled, and where is it not justified? So these are very interesting questions, and they get more interesting when the government gets involved. Okay, so in the United States, these are not questions that a business owner and an employee are free to work out on their own. There's actually a lot of regulation and law surrounding these issues that we'll talk about. We're going to talk about various laws promoting civil rights, and we're going to define civil rights as the protection of disadvantaged groups. We're going to talk about the very first Civil Rights Act of 1964, signed into law by President Johnson, LBJ, as well as the ADEA, Age Discrimination in Employment Act. We didn't talk about age discrimination yet, but we'll talk about that. We'll talk about Title IX. Title IX has to do with discrimination at schools, and it was signed into law by President Richard Nixon, and it's been the law for, over 40 years now. We'll talk about the ADA, Americans with Disabilities Act. See, these are some of our most vulnerable citizens that do have a hard time finding jobs and finding accommodation. So we'll talk about the laws impacting them. Finally, we'll talk about the most recent civil rights law called GINA. Okay, GINA was called Civil Rights for the New Millennium, and it was signed into law by President George W. Bush. And I'm going to leave this as a teaser. See if you can think, what does GINA protect? And we'll find out toward the end of the lecture. Okay, so liberty and equality, we've talked about this. They're two core American values. So the Declaration of Independence affirms freedom and equality for all Americans. We hold these truths to be self-evident. All men are created equal endowed by their Creator with certain inalienable rights, and among these are life, liberty, and the pursuit of happiness. So right back to the founding of our country, we have affirmed the inherent innate freedom and equality of all people. And we've also had amendments to the Constitution that affirm equality for certain disadvantaged groups. For example, in the aftermath of the Civil War, during the Reconstruction era, we passed the 13th Amendment, abolishing slavery. Okay, slavery was obviously a glaring inconsistency. How can we say that people are free and equal if we have a system of slavery and eventually slavery was abolished? Then we had the 14th Amendment, equal protection and due process. In this amendment, we told state governments you may not discriminate against people within your state boundaries. So you must treat them equally. You must provide everyone with a fair legal process. And again, it took a while to work that through the system. Now, we had the 15th Amendment that prohibits race restrictions on voting. And finally, during the Progressive era, the 19th Amendment, which affirms a national right for women to vote. Now remember, there are different visions of freedom and equality. We talked about this, and they differ in terms of government involvement. Negative freedom requires government absence. This is also called freedom from government interference. This is government leave me alone freedom. Then you have so-called positive freedom. This requires government aid and intervention, freedom to certain benefits that the government provides. This is government help me kind of freedom. The idea that are we truly free if we don't have certain basic needs met. Same thing with equality. We talked about this, equality before the law, also sometimes called equal dignity. This means that the government treats everyone the same, that justice is blind and the government does not discriminate. Equality of opportunity, also sometimes thought of as equality of result, means that the government helps certain disadvantaged groups. So the government labels certain groups and says that these groups have been historically disadvantaged. They're in need of government aid to level the playing field. And so justice is not blind. We're going to look and see what group you belong to. We're going to talk about how this applies in the context of civil rights. The term civil rights, again, refers to protection of disadvantaged groups. So equality before the law would mean the government treats everyone the same. Equality of opportunity means the government kind of peaks. It's not 100% blind. It identifies and affirmatively helps certain disadvantaged groups. So on the one hand, civil rights can mean eliminating discriminatory laws. Okay, this would be the 14th Amendment, equal protection and due process. This would be eliminating the Jim Crow laws, the laws that require black and white people to ride in separate carriages, for example. Okay, those laws are discriminatory. That's the government that is not treating people equally, and civil rights would mean eliminating those laws. Civil rights can also mean passing laws against discriminatory behavior by private individuals. So again, we discriminate all the time, and some of the discrimination is just a normal part of living. You know, when you go through a menu and you pick out the items on the menu that you think are tasty and the items on the menu that you think are a good value. Okay, you're discriminating. When you screen for a new hire for your small business, you're discriminating based on education and demeanor and professional appearance. Okay, so we discriminate all the time. Civil rights can mean passing laws saying these are the protected characteristics that you may not discriminate based on. Now, sometimes civil rights and individual rights can be in conflict with each other. Can you think of an example? If the government says, I know that you want to hire somebody young and hip for your internet startup, but you may not discriminate against old people. Okay, so whether or not you agree with that law, maybe you say, yes, I agree with that law. You should not, disadvantage grandpa in hiring. Give him a chance with the internet startup. But it is a restraint on the freedom of the person that's doing the hiring, okay? Maybe you come from a particular community, maybe you come from a Greek community or Irish community or Italian community or African American community, and maybe you start a small business and you want to reach out and hire disadvantaged people in your own community. And civil rights laws could prevent you from doing that. Okay, that's a restriction on your freedom. Some civil rights laws can restrict freedom of speech if they say that you can't say certain things because it could be harassing to people based in certain groups, right? So you can't sexually harass or racially harass with what you say. We would all agree that that's morally wrong. You don't want to do that, right? But when you have a law against it, that law is obviously in tension with free speech. Or sometimes civil rights can be in tension with freedom of religion. When it comes to the protected group of members of the homosexual community and their desire to see same-sex marriage implemented, and then you have others who hold to traditional religious beliefs and don't believe in same-sex marriage. Okay, there you have a tension between civil rights and religious freedom. So this is a very interesting conundrum. To what extent should the government be involved in enforcing good behavior, preventing discrimination against these certain characteristics, but at the same time limiting our freedoms? Remember, every time the government gets involved, we trade a little bit of our precious freedom. Sometimes it's absolutely worth it and necessary, and sometimes we wonder, is this absolutely worth it and necessary? So the very first civil rights law, let's talk about that. Civil Rights Act of 1964, signed by President Lyndon Johnson. Title VII of the Civil Rights Act prohibits private employers from discriminating based on certain protected characteristics. So this is what we were talking about earlier. This is the very first list of things that you cannot consider when you're hiring an employee. So here it is. You cannot consider race, color. That's an old-fashioned term. It just means the color of your skin within your race, religion, sex, and national origin. Now, this is obviously a well-intentioned law. We don't want employers to discriminate based on these categories. At least, under most circumstances, it would not be appropriate. However, it's had some unintended consequences. So remember, we talked about the difference between criminal laws and civil laws. Okay, so the Civil Rights Act is not a criminal law. You will not, in general, be put in jail for discriminating or being a sexist, right? What it is, it's a civil law. This means the person that you harm by discriminating against them, that person has a right to go and file a lawsuit against you and seek money, okay? So if you believe that you've been discriminated against or harassed based on a legally protected characteristic, then you can file a lawsuit, go after that person, show that you've been damaged, and then they have to pay you money. The problem is that lawsuits are very expensive and difficult and time-consuming to defend. And so in 99% of the cases, the employers would rather settle out of court. Okay, so they'd rather just pay the employee some amount of money to go away. All right, in my career as an employment lawyer, I've been doing this 18, 19 years now. Very, very few cases go all the way to trial. So the vast majority of cases are going to settle. And when a case settles, you never really find out, did unlawful discrimination take place or not? Doesn't matter. It's a business decision to send the employee away with some money. So as you can imagine, this is an incentive for attorneys. Wherever there's money, you're going to find attorneys congregating. This is how it usually goes down. So you have an employee. The employee is not happy at work. Maybe they've been laid off, or maybe they've gotten written up for some things and they feel like they're in danger of being fired. They go to an attorney and they said, hey, how can you help me? And the attorney says, well, what's your race? Have you ever felt uncomfortable because of your race at work? What's your religion? Has anybody ever said anything to you that was critical of your religion? How about gender? Have you ever felt uncomfortable about your sex or your gender or your sexual orientation at work? Or how about your national origin? Has anybody ever made fun of your accent, for example? And then the attorney can pick through that and come up with a lawsuit. And I have seen everything, okay? I've seen lawsuits by women claiming they've been harassed by their male supervisors. I've seen men claiming that they've been harassed by their male supervisors. So you can have same-sex sexual harassment as well. I've seen men complaining that they've been harassed by their female supervisors. I had one case where a great big fellow said that his little bitty supervisor threatened him if he did not sleep with her, that she would fire him. And the supervisor said, no, I would never do something like that. It was kind of a he said, she said situation. Nonetheless, the company ended up settling the case, giving the guy some money to go away because it was so expensive to keep fighting the case. In terms of race, I've seen lawsuits by Black employees complaining discrimination by white supervisors, cases by white employees complaining about discrimination by Asian supervisors, complaints by Black employees claiming discrimination by their Mexican supervisors. Right? I even had a case. This was an Italian employee named Mario. Mario was kind of handsy with the ladies. So the women in the office complained that Mario was doing things like pulling on their ponytail or giving them those crepey shoulder massages. And that, on one occasion he supposedly smacked the young lady on the rear end with a shopping bag, okay? And the Human Resources Department was at their wits' end. They went and talked to Mario. They said, Mario, you cannot do this. This is not right. You're going to get us in trouble. This is a violation of our procedures. It's a violation of civil rights. But Mario, for whatever reason, couldn't control himself, and Human Resources ended up firing him. So what does Mario do? He goes around and he sues the company for discrimination based on his national origin. He says that you fire me because I am Italian. And the company didn't want the exposure and the cost of fighting Mario over this, so they gave him a good settlement just to go away. Okay, so the question is, do these civil rights laws, does the Civil Rights Act of 1964, does it actually reduce immoral discrimination, or does it just proliferate lawsuits? I think that's a good question to ask. Okay, President Johnson also signed the Age Discrimination in Employment Act of 1967. So they realized, oh, we think we've left off a protected category. We certainly don't want anybody to discriminate against grandma and grandpa, so we're going to prohibit age discrimination. So ADEA prohibits employers from discriminating against old people. And if you are going to prohibit discrimination against old people, you have to define what you mean by old people. Okay, so what's the cutoff? At what age are you prohibited from discriminating against old people? I'll let you guys think about that for a minute. Okay, so are you old when you hit 70? Our president is over 70, and the contender, the challenger, Joe Biden, also well over 70. Okay, so maybe you could consider that old, maybe 65, 63. No, the ADEA prohibits employers from discriminating against employees over 40 years old. Now, I object to that. I think that when you turn 40, you are at the peak of your career, right? I mean, we definitely are not old, the people who are in their 40s. Nonetheless, that's how it's defined. So how does this work out in real life? What happens is that if a company has to do a layoff, they will analyze the ages of their employees. They'll do spreadsheets and Excel charts, and they'll analyze the average age before the layoff and the average age after the layoff, and they want to make sure any disproportionate impact falls on you guys, workers under 40. Okay, that's very interesting. This Age Discrimination in Employment Act, it is a one-way civil rights act. Okay, so we've seen with respect to things like race and gender, you can have majority race sue for discrimination. You can have men sue for discrimination, but in the ADEA, you're only protected if you're over 40. Employees who are under 40 are not protected. This creates a hardship for younger employees, and it also creates a lot of paperwork for human resources departments, as well as again, endless lawsuits for attorneys. So we have a bureaucracy that helps enforce Title VII and other civil rights laws, especially in the workplace. So that bureaucracy is called the Equal Employment Opportunity Commission, or EEOC. And if you click on the link there, you can read more about the EEOC. So if you believe that you've been discriminated against or harassed, you basically have two options. You can file a complaint with the EEOC and they'll investigate it for free, or you can hire an attorney, and your private attorney can file a lawsuit in court. This is kind of a case that you get what you pay for. Usually, if you can find a private attorney to take your case, you're going to have faster access and more pressure to put on employers to settle than if you just file a complaint with the EEOC, although you can do that as well. Again, these lawsuits are extremely expensive to defend, so for this reason, the vast majority of employment discrimination cases settle. The cost of litigation are passed on to consumers. So this is an important point. When you have someone file a lawsuit and the employer settles, they pay, $10, $20, $30, $40, $50,000 so that they can avoid paying $200,000 to take the case all the way to a jury trial. When an employer makes that business decision, the money is not going to come out of the pockets of the supervisor who allegedly discriminated. It's not going to come out of the pockets of the executives. Basically, this is baked into the cake. These big companies have legal budgets, and these costs are passed on to consumers, to you and me. So, for example, grocery stores will have a budget for these kinds of lawsuits, and that will result in higher prices of groceries. All kinds of employers all over the country handle these lawsuits, and again, the consumers are the ones who pay for them. The lawyers will collect their fees, so the companies have to pay for the lawyers that represent them, like I do. And then if you're an employee and you have an attorney, usually you don't have enough money to pay your attorney up front, and so they'll give you, or you will give your attorney a cut of what you recover, right? That's called plaintiff's contingency fee. So if you're an employee, you file a lawsuit, you recover, let's say, $30,000, and usually you have to give your attorney at least a third of that, or $10,000 of the $30,000. Okay, and so really we have this whole scheme that's supposedly to prevent discrimination and harassment, but really it's more like a full employment provision for attorneys. So one of the tensions in civil rights law is that equal rights do not guarantee equal results. We can imagine some kind of utopia where there's a perfect gender and racial mix at every level of society, but in fact that's not real life. So even if you remove barriers, you're going to see different pockets of people from different groups at different levels and segments of society. Okay, and you can assume that some of that is going to be due to immoral racism or sexism, etc. But a lot of it just has to do with cultural values, personal preferences, family influence. So there's lots of reasons for how people get to where they are in life, and they don't all boil down to pure racism. So the question is, when things get really complicated and there's so many variables, what do? Do you strive for that perfectly randomized mix of humanity at every level of society? What do you do to address historic injustices? And one one proposed solution is affirmative action. So policies like affirmative action push for equal results by giving preference to a particular group. So for example, if you're talking about college admissions to a prestigious college, this means that the college might lower its standards for people from certain disadvantaged groups in order to get a more diverse mix. There was a lawsuit recently against my alma mater, Harvard. And in the lawsuit, it was alleged that they discriminated against Asians because Asian students, if you look at statistics, Asian students in general will have higher test scores, higher grades than students from other demographics. But Harvard didn't want Asian representation to be heavier in its classes than in the general population. They wanted to have more diversity, so they actually downgraded Asian American applications in favor of applications from other groups. So the Asians that filed the lawsuit said that was discriminatory. The court actually agreed with Harvard and said diversity is an important goal, and even if you have to discriminate to achieve diversity, that's okay in this situation. But you can see some of the tensions inherent with affirmative action and diversity programs. Now, the Supreme Court has held that affirmative action is legal. It does not violate civil rights laws when it's done with the intent to remedy historical injustices. But the question is, okay, how far can you go? How long do you have to keep an affirmative action program in place until the injustice is deemed mitigated? Chouette versus BAM, you can click on the link there if you like. In the PowerPoint, that's a little news clip. It's a case in front of the Supreme Court where University of Michigan actually decided to discontinue affirmative action at the University of Michigan. And the Supreme Court said, look, it's up to the people of Michigan. If they want to have affirmative action programs, that's fine. If they want to discontinue them, that's also fine. Sonia Sotomayor, one of the Supreme Court justices, had a very fierce dissent to that decision, and you can click on the link and hear her dissent. So there are, arguments on all sides of this question. Some people argue affirmative action hurts minorities instead of helping them, which is, it's very sad if you have a well-intentioned policy that hurts the people it's supposed to help. One of these people is Thomas Sowell, S-O-W-E-L-L. He's a black economist, and he's done a lot of research in this area of discrimination and differences between different people groups, and he's come to the conclusion that it's actually better for minorities if they just compete based on merit alone. And he points to his own life. In addition to his research, he feels that before affirmative action was very common, he's a little older, so he remembers before we had a lot of affirmative action programs that he was treated very respectfully because everybody assumed he made it to his position based on his own efforts. But that after affirmative action programs were in place, that he was actually more disrespected because people assumed that he got there not by his own merit but by affirmative action. So, kind of a very interesting tension when you're talking about civil rights. To what extent are you guaranteeing equal rights, and to what extent are you actually trying to impose equal results, and can equal results even be achieved? Here's another example when it comes to women who work. Okay, so we've all heard the statistic that women only make 70 cents compared for each dollar that men make. Okay, and how do they get that statistic? Well, they average the wages of all men who work full-time, and they average the wages of all women who work full-time, and lo and behold, women receive less. But what they neglect to take into account is the personal choices that are made by men and women. So, you have this wage gap when it comes to women, but actually you have a death gap when it comes to men. Men gravitate toward jobs that are dirtier, more dangerous, more stressful, and men die on the job in greater numbers than women. So partly as a result of this choice, some work actually pays a premium because it is more dangerous, more stressful, and more risky. So if you're going to talk about the pay gap for women, you probably have to talk about the death gap for men. We already have civil rights laws that prohibit employment discrimination based on gender. We've had these since 1963. So what the government's talking about, and this has been imposed in various states, including California already, but we don't have it on the federal level yet, is something called a Paycheck Fairness Act. So right now, under the existing civil rights laws, if a woman believes she's been discriminated against based on her pay, she can file a lawsuit and she has to prove that it's due to discrimination. These new types of Paycheck Fairness Acts, what they do is they assume that any differences in pay are going to be as a result of discrimination, and the burden is on employers to justify any pay differences. Okay, so employers have a lot more restrictions in how they can pay their employees, a lot more regulation, a lot more red tape, and employers are going to be a lot more reluctant to negotiate individual wages with individual employees. Instead, you see employers in California, for example, where you have a Paycheck Fairness Act trying to normalize and equalize and standardize so everybody is paid in lockstep. Again, the assumption that differences in pay is due to discrimination is simply incorrect. I'm sure that discrimination plays into it in some instances, but women choose jobs that are less dangerous. In addition, men choose to go into the sciences and women choose to go into service work like education. So if you go to Louisiana Tech, there's no sign on the engineering building that says, stinky girls not allowed. In fact, Tech and lots of high schools put a lot of money into encouraging women to go into STEM subjects. But for some reason, many women choose not to do that. Instead, they go into elementary education or psychology or social work and other jobs that don't require as rigorous of an educational background and don't pay as much. And these are their free choices. In my own life, okay, so I have lots of colleagues who are women attorneys, and these are, Ivy League educated, tough feminist women. Many times these women make more than their husbands. So when it comes time to have kids, they have to make a decision. Do they give up their lucrative careers to stay home with the kids, or do they ask their husbands to do that, or do they come up with some other solution, right? And so I've had several women co-workers who make more than their husbands, and their families make the kind of logical decision that the husband is going to stay home and take care of the kids. And invariably, these women, I would sit and have lunch with them or coffee breaks with them. They were not happy. They would talk about how jealous they were of their husbands staying home, how they thought their husbands were not doing a good job and they could do a better job, and how if only their husbands made more money, then they could stay home and their husband could work. So, very interesting, and I don't think that was a good formula for a happy marriage, right? To have a woman working who resented it and a husband staying at home who perhaps is not very good at it, right? So research shows that, even though American women, we have so many options. We have a lot of freedom of choice in the careers that we can pursue. But the freer we are, the more women tend to choose traditionally female careers and options. So, there's kind of a lack of women partners at the highest levels of law firms. And there's a lot of pressure for law firms to recruit and retain women partners. But what happens is right when women get about to be at the point in their careers where they're up for partner, they start to have kids. And many of my female colleagues have made the voluntary choice that they would rather scale back, work part-time, stay at home with their kids at least part of the time, than put in the hard work and the long hours necessary as a partner at a big law firm. So, very interesting how people make decisions for lots of different reasons. So I'm not saying that discrimination never occurs with women in the workplace, but you know, a lot of this pay gap is due to choices that men and women make. And men and women have, just like they have different physical abilities, they have different perspectives on life many times, and they make different choices when it comes to career and family. So what these proposed Paycheck Fairness Acts would do at the state and federal level is basically give employers less flexibility, less freedom in how they determine pay. Okay, they're trying to equalize results, even where the underlying situation may not be the same. And if you want more information, you're welcome to click on that link at the top of the slide. All right, let's talk about Title IX, signed by President Nixon. So this has been in effect for well over 40 years, almost 50 years now. Title IX of the Education Amendments, prohibiting sex discrimination in any education program receiving federal financial aid. And this includes aid in the form of student loans. So there's only a handful of private colleges across the nation that do not accept federally funded student loans. But aside from this very small group of colleges, this applies to all institutions of education, public schools and higher education institutions. So we have, and again, do we want discrimination in our schools? No, we do not, okay? But let's take a look at how Title IX is enforced. We have a bureaucracy for that. It is enforced by the Department of Education, Office of Civil Rights. So if you feel that you've been discriminated against based on your sex or any other protected category, you can click on that link there and file a complaint with the Department of Education, Office of Civil Rights. One area where Title IX is often applied is in the area of sports. Okay, so Title IX has been used to enforce equal opportunity for men and women in athletics. And one of the goals of Title IX is to try to get equal results for men and women's sports, that participation opportunities for males and females would take place in numbers proportionate to enrollment. So the goal is that you would see participation in sports equal between men and women. There's a couple problems with that, and again, it relates to individual choices. The question is, do men and women want to go into sports in equal numbers? You know, maybe not. Also, do alumni and fans want to watch men and women's sports in equal numbers? You know, it's a free choice whether to watch Lady Texters or men's basketball. You know, no disrespect to the Lady Texters, but men's basketball is more interesting at a higher level, and people pay more for tickets. The fans are more interested. Then you have football. Football is a game played by male players. So it's very difficult to balance out male and female athletics. And schools have whole Title IX officers in their sports departments that try and count and make arrangements and try and equalize men and women in sports, and it's not easy to do. Public schools are basically all schools that accept public funds, which is almost all schools, must carefully count the number of men and women who participate in sports. What this means is that when times are tough, men's sports teams are more likely to be cut. Here's one example. Quinnipiac University. In 2008, we had an economic downturn. Quinnipiac had to cut costs, and it actually dropped its women's volleyball team along with its men's golf and outdoor track and field teams. So, you know, they dropped multiple men's teams, and they also dropped women's volleyball. In order to equalize the numbers, they decided what we'll do is we'll create a competitive cheerleading team. So we already have cheerleaders for football, the thought went. So what we'll do is we'll take that and we'll build a competitive cheerleading team that will go to conventions and compete, basically varsity cheerleading squad. Well, women's volleyball was upset and they filed a lawsuit, and they said cheerleaders are not real athletes and therefore do not count for Title IX purposes. And the case went up to the Second Circuit, and the Second Circuit had to answer this very important question: is cheerleading a sport for Title IX purposes? So what do you guys think? Do you think cheerleading should be a sport? Do you think the decision on this should be made by a Second Circuit judge? I'm guessing this judge is probably nerdy and an academic, never been to a football game, never watched a cheerleading practice rate, so that should this cranky old Second Circuit judge be able to decide whether cheerleading is a sport or not? Actually, the judge was on Team Women's Volleyball, and they put pressure on Quinnipiac University to settle the case, which it did. So then Quinnipiac University, which was already struggling financially, had to go and put more money into women's sports. Okay, so they had to bring back volleyball. They had to add varsity women's golf and rugby. They had to increase their scholarships, raise the level of competition, increase its commitment to women's track by increasing coaches and competitions. It had to spend at least $5 million improving women's varsity locker rooms, etc. And it had to hire a referee to monitor its progress. Okay, so you can see, the consequences of this lawsuit by the women's volleyball team on Quinnipiac University, and the power that the Second Circuit and the Department of Education bureaucracy has on the structure of school athletics. Very interesting. So here's a thought question. Who do you think should decide whether a school's athletic program is fair or unfair to women? So I'm sure there are schools that are not fair to their female athletes and disregard them and ignore them. So are we totally helpless? Are women athletes helpless when it comes to women's sports? Do we have no ability to stand up for ourselves without the help of Second Circuit judges and the Department of Education? Well, I think that women do have a lot of buying power. We have power in where we go to school. If you don't like a specific college, you can go to a different one. We have power in what programs we support. Either you're an alumni, you can give to athletic programs that you support, and where you go as fans. You can support athletic teams as fans. So there's lots of things that you can do on a personal and individual level to improve women's athletic programs without having a Second Circuit judge counting individuals on rosters and trying to decide between women's volleyball and competitive cheerleading. Let's talk about the Americans with Disabilities Act. It was signed by President George H.W. Bush in 1990. ADA requires places of public accommodation to be disability accessible, and it also requires employers to reasonably accommodate employees with disabilities. So people with disabilities are among some of the most neglected members of our society, and this law absolutely was well intended to help people with disabilities be able to enjoy the same facilities and participate in the same workforces as people without disabilities. Like I said, I have a son who is disabled. He's had a very hard time finding a job. Unfortunately, the ADA is probably the most abused of all the civil rights laws, and we'll talk about that. So unfortunately, it's very sad, but what happens is you have these serial litigants using the ADA to target small businesses over small violations. So the EEOC and other government agencies that are responsible for putting out regulations implementing the ADA have put out very, very detailed regulations. So the regulations cover the number of handicap parking spots and their location in the parking lot. They cover the height of the counters and the width of the doors and the placement of the paper towel dispenser, etc. Very, very detailed, very easy, especially for a small employer to trip up. So what happens is you'll have someone in a wheelchair that will partner with a law firm, and then they'll go around and they'll visit these little businesses, and then the next week you'll see 5, 6, 7, 8 lawsuits by the same plaintiff, same law firm, against all of the businesses in a little strip mall. This is just one example. This is a guy, Vikas Patel. He owns an Econo Lodge in California. You can see he's just a regular guy, not a huge profit margin on an Econo Lodge. And he got targeted by one of these serial ADA litigants and ended up paying a lot of money. Even people who are disabled wonder, does this create hostility toward people with disabilities? Does it harm them more than help them? Many people who are disabled don't like the, of course, some people enjoy having the nice handicap parking, right? But others feel that this itself is kind of stigmatizing, and again, they'd rather enter society on their own terms. Employers also worry about whether and how the ADA applies to online businesses and websites. It's very nice when you can have a website that has captions for the deaf, or it has descriptions of pictures for the blind. The question is, are these accommodations required? And what about small businesses that may not be able to afford the technology? So these are all concerns, and my problem is that it would be one thing if stores and companies were asking, how can we enhance the experience of our disabled customers, but instead the question they're asking is, how can we comply with these very, very detailed regulations and avoid expensive litigation? I would like you to click on this link in the PowerPoint when you get the chance. This is the story of a young man named Kevin. Kevin is disabled. He's in a wheelchair. He can't get around by himself without a wheelchair. But he had a group of very dedicated friends that came up with this idea. They were going to backpack around Europe, and they made a special backpack just for Kevin. And they took turns carrying him and went to all these really scenic places that normally would not be disability accessible. And that's an example of what just pure friendship and pure love and affection can do for someone who's disabled, people who are acting out of the kindness of their hearts instead of acting out of a fear of government regulation and litigation. And you can see there's just a different spirit about the whole thing when it's friends helping friends of their own free will. So the question is, all of this government intervention, has it helped disabled Americans? And I think that's an open question. All right, I told you I would do the big reveal, the civil rights legislation for the new millennium. Are you ready? This is Gina. Genetic Information Non-Discrimination Act of 2008, signed by President George W. Bush. Create a new protected category. GINA prohibits the use of genetic information in health insurance and employment. Now, I have to say, I think this legislation was a little ahead of its time. I have not, in the past 12 years or so, I have not seen any litigation on GINA. But the EEOC has been very busy. It has put out regulations, and these regulations prohibit even casual questions about your family history. For example, under the regulations, if your coworker, your employee comes to work and they're kind of sad, and you ask, why are you sad? And they say, oh, my aunt was diagnosed with breast cancer. You're not allowed to ask, does it run in your family? Or if they say, oh, my dad, he was diagnosed with heart disease, they're not allowed to ask, have you been tested for it? Perhaps innocent questions, but God forbid they could disclose your genetic information and you could end up being discriminated against. So again, this is another area where government has intervened to protect us using very detailed regulations. Some people argue civil rights can be achieved without special government intervention. This is Walter Williams, professor of economics at George Mason University. He says, in 1947, when the Brooklyn Dodgers hired Jackie Robinson, why did racial discrimination by major league teams begin to drop like a hot potato? So this was before the civil rights movement. Nonetheless, Brooklyn Dodgers began to integrate black players. And it wasn't feelings of guilt by white owners or affirmative action or anti-discrimination laws. The fact was that Jackie Robinson was good. Okay, it turned out there was a huge pool of black baseball talent in the Negro Leagues. Black players won the National League's Most Valuable Player Award for 7 consecutive seasons. So Walter Williams is saying that people are able to integrate, people are able to overcome their prejudices without extensive government interventions that erode our freedoms. The question is, 50 years after the original Civil Rights Act, do employers discriminate less? They're certainly more cautious. Okay, so I give lots of seminars on what you can and can't say at the office, can and can't say in a job interview. So we're all very, very cautious. Has it really eliminated discrimination? And here I want to draw a parallel. We talked about freedom, and freedom is one of the fundamental American values, and our founders put all these protections for our freedom into the Constitution. Ultimately, they believed that the defense of our freedom was up to you, the people, okay, the American people. The buck stops with them. We have to stand up for our freedom. And likewise with equality. So we have many, many attempts by our government to help create an environment where people can exercise equality, be treated equally and fairly, but none of these laws and regulations will ultimately eliminate discrimination, and that is up to me and you. That's up to our individual choices, how we treat people who may be different from us, how we treat people who may have disabilities or come from other backgrounds. So I encourage you to think about that. What are you doing to protect your freedoms, to protect our freedoms? What are you doing to work toward an environment of equality in the places where you live and you work and you study? So I'm going to leave it at that the buck stops with you, and encourage you to go out and do what's right. Thank you very much for joining me And Political Science 201 quarantine version. Please don't be a stranger. You're welcome to stop by my office at Louisiana Tech, GTM 122. Once quarantine is over, there's my email. Please email me. And good luck on the last, well, it's not the last test, but the last quiz. Good luck on the last quarantine quiz. And I look forward to seeing everyone in the fall.